Hi, good afternoon, everybody. This is Shuming from the National Immigration Law Center. Welcome to our webinar to provide you with updates on immigrant rights issues. So we're glad you could join us today. We certainly have a lot to talk about. Some of the NILC staff are going to discuss DACA litigation, the upcoming Muslim ban Supreme Court hearing, and changes to the public charge definition. And we're also very fortunate to be joined by Stephanie Tetro, who is the director of the Tennessee Immigrant and Refugee Rights Coalition, to talk about the recent worksite raids that happened in Tennessee. So I'm going to first turn it over to my colleague, Josh, who is going to talk about DACA litigation. Josh?
Thanks, Shuming. So I want to just talk briefly about some of the litigation that has happened since the Trump administration decided to end the DACA program in September of last year. There were about 10 lawsuits that have been filed that are in various stages at this point. And I wanted to comment specifically on 3 of them. 2 of them are Regents of the University of California versus DHS and Bataya Vidal versus Nielsen. I should say there's actually several other cases that have been consolidated with those, including a case brought by the state of New York and several other states, a case brought by the state of California and a few other states, other cases brought by individuals and other state and local governments that have sought to bring accountability and to reinstate the DACA program. And in each of these cases, in California and the Bataya Vidal cases in New York, we were able to achieve success earlier this year, as many of you are aware, through court orders that require USCIS to accept DACA applications from anyone who's had DACA at any point in the past. So if someone has DACA currently or their DACA expired after September 4th, 2016, they can submit a DACA renewal application. If their DACA expired before September 4th, 2016, they have to file as if they were applying for the first time, but that application will be considered. And so far, we've heard that applications are getting processed. They're getting approved within 4 to 6 weeks. And as I'll discuss in a couple of minutes, we're already starting to see people getting renewals of their DACA and new extended terms going out until 2020. So that is one source of good news. The other source of good news that I wanted to highlight is from a case in Casa de Maryland, which was filed in the District of Maryland, and Casa was the lead plaintiff among a number of other grassroots organizations and individuals who sought relief in that case. And they were able to obtain an injunction that says that the government has to abide by the information sharing restrictions that were in place before September 5th, before the end of the DACA program. And so the government may not use information that DACA recipients or applicants provided for deportation purposes, except in a few very narrow circumstances. And so that is another resource for people with DACA and another way to ensure that people with DACA are protected from deportation. And to the extent that there seem to be issues around that kind of information sharing, that's something that the plaintiffs in all of those cases, Bataya Vidal, in which the National Immigration Law Center represents the plaintiffs, as well as Casa de Maryland, which is represented by the Lawyers Committee for Civil Rights, all of the plaintiffs would be interested to hear about any issues that people are seeing around either information sharing or problems with these DACA renewal applications. But as I mentioned, we're already starting to see good news. And one of the ways that we know that we're seeing good news is because, as part of the order in the California case, that Regents of the University of California case, USCIS has to provide the court with a quarterly report with statistics on how DACA renewals are being processed under the injunction. They published their first report on April 2nd, and a few of those statistics are here, including that thanks to the injunctions, a little less than 32,000 DACA requests had been approved as of the beginning of this month. In total, between January or March of this year, a little more than 55,000 folks have been granted DACA, and that includes people who had applied either before September 5th or in that window between September 5th and October 5th of last year. There have been some denials, but only 70 of those denials were for applications that were received on or after January 10th. I'd note that these are denials after applications were actually accepted for USCIS. So the other DACA denials were for folks who applied either, again, before September 5th or in that 1 month window that was granted for a limited number of people to seek renewal. Moving to a few more of the statistics, there's now currently 693,850 individuals who have active work permits through DACA that go through 2020, and 54,850 of those are set to expire in 2020. And then there's a little more than 9,000 renewals that are pending from individuals whose DACA has expired. Looking forward, there were a large number of people who had DACA that expired in April, whose renewal application was pending, but as we look later in to May and June, it looks like people have yet to start applying for DACA. Less than half of the DACA recipients whose work permits expire in May and June have been able to apply, and so that's an area where we think enhanced outreach and paying attention to resources for folks who want to apply for DACA is really important. And that is all that I really have to share right now. Looking forward into the next couple of months, both the California cases and the New York case are currently on appeal, and so there will be arguments in those cases probably at some point during the summer, and then we'll see where we go from there. But for now, we're eager for folks to take advantage of this window when USCIS is accepting DACA applications, especially for individuals whose work permits are expiring in May and June, to make sure that people are aware of this opportunity and are submitting their applications. They're aware of the protections against information sharing so that they're able to get that additional 2-year period of protection from deportation and work authorization. And I'm happy to answer questions in a few minutes, but I think now I'll turn it over to Jackie.
Great, thank you. So I'm going to talk a little bit about the latest updates on a proposed rule that is going to change the way something called public charge functions. So next slide, please. Just a kind of brief overview. Next slide. Is it not working? Okay, I guess I'll just start. Next slide when we get a chance. There we go. I'm going to talk just a little bit about what public charge is, and we've had several webinars about this, and there have been more in-depth opportunities, and we will have future briefings that go into further detail. So if you go back just quickly, public charge, one slide. Public charge is a term that's used by U.S. immigration officials to refer to a person who's considered to be likely to become primarily dependent on the government for subsistence. This is really a 100-year-old part of U.S. immigration law. And the consequences of this is that if an immigrant is found to be likely to become a quote-unquote public charge, they may be denied admission to the United States, or they may be denied the ability to adjust to lawful permanent resident status or green card. And for the time that public charge has existed in U.S. immigration law, historically, deportation on public charge grounds has been rare. It's almost unheard of for someone to be deported. Next slide, please. So the important aspect here is that there's only been in the last few decades, only two types of benefits have been considered for public charge determinations. One of those is cash assistance for income maintenance, and the other one is institutionalization for long-term care. So long as you didn't use cash or long-term care, cash and care, you were okay. So the law excluded benefits such as Medicaid, health benefits, housing benefits, those kinds of things. It was a very narrow determination of what could make someone be determined to be a public charge. Next slide, please. Okay, I guess next slide and get a chance. Nope, okay. I guess we'll just keep on going. It's important to know that the public charge is only assessed at 2 moments. It's not a continuous test. There's a test that's made when a person applies to enter the United States, or when that person applies to adjust status to get their green card or LPR status. So again, only when you apply to enter the United States or when you're applying for a green card. It does not apply when does not apply when you're applying to become a U.S. citizen when you're trying to naturalize. So that's really important for folks to know. Next slide, please. So the other thing that's important to know about public charge is that it's a totality of circumstances test. It's not as though if you used cash assistance or you had long-term care that you're automatically determined to be a public charge. The officer has to look at the applicant's age, their health, their family status, financial status, education and skills, and then the affidavit of support if they have a sponsor of their sponsor that's sponsoring them for their immigration status. So again, I think it's important that we remember that, and that a good immigration attorney can, paper up someone's case if they have used a benefit to make the case that the other factors outweigh that. Next slide, please. Okay, I guess we'll just keep on going. So then I'm just trying to figure out what okay, the important thing to keep in mind about public charge is that there are certain exemptions to public charge. Some people are not subject to public charge tests. For example, people on humanitarian visas, refugees, asylees, survivors of trafficking, domestic violence, or other serious crimes, and others are not subject to public charge tests. Again, neither are people applying to citizenship. So it's important to know if you're talking with someone whether they even are subject to public charge. The other piece that's important to know and to keep in mind is that the decision about public charge is forward-looking. It's based on whether you're likely to become a public charge in the future, and it can't only be based on what's happening in the past. Next slide, please. That's strange. Okay, actually, can you fast forward past this piece right now? 2 more slides. Oh, okay. I guess I'm going to talk about, if we could just fast forward, just keep on going. Sorry, 1 more slide, please. Keep on, sorry, 1 more quick slide. All right, there we go, the one before. There's been a public charge proposed rule. Sorry, back 1 more, please. There we go. There's been a proposed rule that is looking to redefine public charge and how it's been functioning for about a century in this country, which is that it's been something that the Trump administration has been leaking to the press ever since January of 2017, that they're looking to radically redefine public charge in order to go way beyond cash and long-term care. And we've seen this in an executive order that was leaked in January 2017, and we also saw a draft of a proposed rule that was leaked to the press on February 8th. Next slide, please. The proposed rule needs to go through a series of processes. So it's not like there was already a law that was passed by Congress. And then this is really going to be the regulation that is helping explain how to adopt the rule. And then ultimately there'll be a policy adopted by the agency. So this regulation that the Trump administration is trying to implement needs to be consistent with the law. Next slide, please. The proposed rule content basically is DHS wants to expand public charge to consider a much broader array of services and benefits. The leaked draft includes programs like Medicaid, CHIP, even the ACA, Obamacare, marketplace subsidies. This is particularly disturbing given that we still have the individual mandate even if there's no more penalty for not having insurance. So you're required to have insurance, but if you're someone who's applying for a green card and you use a marketplace subsidy, you get Obamacare, that could be taken into consideration during your public charge test. They're also looking at nutrition programs like SNAP and WIC, housing assistance, energy assistance, LIHEAP, and transportation services. They also are going to be looking at the proposed rule draft that we've seen. There's actually been several leaks, several versions that have been leaked. Also includes benefits received by dependents. So that means if you have a green card holder and they have a U.S. citizen child and they access one of these benefits, that could also be used as part of the determination. Next slide, please. Next slide. So we don't actually know whether or not those are going to be the final benefits that are going to be included in the final proposed rule that's coming out. We know that they're trying to, back one slide, please. We know that they're going to expand it far beyond cash and care. Back one slide, please. But there will be certain benefits that will be likely to be exempt from consideration. In both of the drafts that have been leaked, they will exclude earned, quote unquote, earned benefits connected to work or military service, including SSDI, veterans benefits, unemployment, workers' comp, Medicare, emergency, and disaster assistance. So there will be some benefits that are going to be carved out. Yep, just quickly, the rule is not retroactive. It will not punish people for benefits that they used prior to the rule being published. So if you are talking to communities and there are folks that are accessing these benefits right now, it's important to know that will not count unless they're accessed after the rule is finalized. And there are also going to be other factors that are going to outweigh it. Next slide, please. Okay, I'm going to just give it a quick example. So let's say Angie is a 32-year-old single mother who has 4 children, and she wants to become a lawful permanent resident. She wants to become a green card holder. She, for example, recently completed her nursing degree, and she's working for a hospital, and her sister sponsored her to come to the United States. Let's say her U.S. citizen kids received food stamp, SNAP, and Medicaid while she was in school. Next slide, please. This is a totality of circumstances test. So when they're trying to decide whether or not Angie is a public charge, is likely to become a public charge, they have to take into account both negative factors and positive factors. The negative factors here are that she supports a large family. There is an anti-large family bias here. And also they will take into account whether or not her children received Medicaid and SNAP, regardless of the children's immigration status. The positive factors are that she's working age, she has good health, she has a job, her skills are in demand, and she has a sponsor. So those positive factors can outweigh the negative factors. Next slide, please. So basically where we are right now is that we found out last fall in the Unified Agenda that they're going to be publishing a proposed rule by July of 2018. That draft of that rule went to the Office of Management and Budget in April. And that we're waiting basically for the Office of Management and Budget to do their due diligence and do an analysis of it. And then at that point, it will be published in the Federal Register for people to be able to comment on. They set a deadline of July for that to happen, but it could happen any moment. It could happen today. Well, it couldn't happen today because it didn't happen. It could happen tomorrow. It could happen the next day. So we are just waiting for them to publish this proposed rule. This is why we need, as soon as that proposed rule comes out, we need everyone to comment. We want to try and get about 100,000 comments, and then that final rule will be published. So there will be a period of about 30 to 60 days for people to comment. In the drafts we've seen, it's 60 days. Next slide, please. So what we just quickly next slide. I want to talk about what the public messaging should be about this particular rule. Next slide. Is that this is really an undemocratic end run around Congress. We know that President Trump, next slide, please. There we go. Perfect. President Trump has been trying to pass something like the RAISE Act to change our immigration system to only allow in certain types of people. So he wants to really redo the poem underneath the Statue of Liberty that says, "Give me your tired, your poor," and instead wants to rewrite our immigration system to give us your wealthy, your Norwegian, your people who have PhDs in STEM fields, and really radically redoing our whole immigration system. This is undemocratic. If he wants to change the immigration system, this needs to be done through Congress, not through a regulation. And ultimately, right now, there are already current laws that bar immigrant access to benefits. This is about green card holders. This is about, really hurting families that are together. And 1 in 4 U.S. children are in a immigrant family. So this is going to affect a huge number of kids in particular. This is really bad for our health and economy. And it really forces parents to have to make decisions between, am I going to do what's right for my family and access a benefit that will make my kids or my family members healthier, or better educated and better prepared to join the workforce, or just to live the best life they can live, or will I have to jeopardize my ability to stay together? And this is really going to hurt kids many years to come. We know that when children don't have access to health care and basic food and nutrition, that they suffer educational consequences. If you're hungry, you can't learn, and other negative developments in the forward. Next slide, please. So the next piece is that's the kind of messaging that's more for elected officials. Next slide. The messaging we really want to say to families right now, next slide, is that the rules for immigrants who apply to a green card in the U.S. have not changed. So if you're in the U.S. and you're applying for a green card, nothing has changed. Next slide. And there are many families who are not subject to public charge. You want to remind people about the totality of circumstances. And we really don't think that there's any advantage for families that are currently receiving public assistance to terminating those benefits at this time. So if someone's already on WIC, someone has Medicaid, again, once they will not be counted as part of the public charge test unless they are accessed after the proposed rule is finalized. So given that they've already accessed it, there's really no benefit to getting off it now. Next slide, please. Just basically before the rule is published, next slide, we are going to be just educating folks about this particular public rule, and next slide, please. And after that, the big focus of the campaign is really to get public comments. As I mentioned, we're trying to get 100,000 public comments nationwide saying this is wrong, this is a wrong direction for our country, this is bad for families, this is bad for kids, this is bad for our future, for our public health, and for our economy. Next slide, please. The other final piece is just story gathering. If you know people, next slide, please. There we go, perfect. If you know people that are impacted by this, even if they're taking effect and getting off of benefits before the rule is published, we want to hear your stories. We want to also just help individuals and families share their own stories in order to really educate policymakers and media about what this impact of this proposed rule is going to be. Finally, next slide. Just want to tell you about the Protecting Immigrant Families campaign that many of you have heard about. It's a joint campaign between the Center for Law and Social Policy, CLASP, and NILC. And then, so our final slide with the bit.ly link, please, will be the last slide. It's a bit.ly, just next slide, please. Okay, the campaign is really trying to create a, next slide, please, strategy to fight back against this. We're going to be talking about policy and legal analysis. We're going to be doing communication. We're going to be educating folks. Next slide, please. The way you can get signed up for the campaign and become educated about this, next slide, is to go to the bit.ly link. Again, bit.ly PIF campaign. That's P as in protecting immigrant, I families, F campaign. You can sign up there and you will be able to get updates on the campaign and find out when the rule is published so that we can start the public comment period. Thank you.
All right, thank you, Josh and Jackie. I know that was a lot of information. So as people have questions, type them in the comment box and we'll try to answer as many as we can. We've already been getting several questions while you two have been presenting. So let me ask a few right now. For Josh, there's a question about the information that's protected. I think this is referring to the Maryland court order. And the question is the protected information only for post-September 4th DACA renewal applications?
No, all information provided in the course of a DACA application is protected except in certain limited circumstances. Those circumstances generally involve somebody who has a criminal conviction. And those are the circumstances where the information could be shared back since the beginning of the creation of DACA. So if there's an individual who doesn't have a criminal conviction or doesn't have a qualifying criminal conviction, the information that they've provided in their DACA applications since 2012 has to be protected under the same terms as it was protected under the Obama administration, according to this court order. And so that's a protection that should go pretty broadly. If folks have questions about a particular individual or a particular circumstance, that's something that we'd be happy to talk about more one-on-one. Thanks.
And Jackie, there's a question for you. It says, if someone is classified as a public charge, are the person's undocumented family members, such as siblings, parents, children, considered a public charge as well?
So just to be clear, public charge is about someone's immigration case. So an undocumented person right now doesn't have, most people don't have an open immigration case. So it's really about the fact that this is about that individual being considered to be a public charge. And, you know, if and when other members of the family do apply to adjust status in the future, then they will have to go through their own public charge test. But public charge only applies when you're applying to enter the country or when you're applying for a green card. There's no other time that the public charge test is administered.
All right. Josh, another DACA question for you. Are people who've never had DACA before able to apply now, or is it only DACA renewals that are being accepted?
Right now, only people who have had DACA at some point in the past can apply. And so if somebody hasn't had DACA ever before, they are not eligible to, USCIS won't accept their application right now. But even if you had DACA a long time in the past, that's enough for you to be eligible to apply for DACA again in the right now, with the understanding that if someone's DACA expired before September 4th, 2016, then that person needs to file the full initial DACA application, not the shorter renewal form of the application.
All right, thank you. And Jackie, there's a question about whether the public charge assessment would include the use of financial aid for college or educational programs.
So it's a great question. We don't know. I mean, the final draft has not been published yet, so we don't know what's going to be in the final rule. In the first draft that was leaked back in February, it was unclear. In the latest draft, they excluded grants like Pell Grants and so forth and higher education assistance. But we really don't know what's going to be in the final rule. We just know that the rule is going to be trying to expand beyond cash and long-term care. And we will keep you updated once we get the final list of what's in and what's out.
All right, great. And Jackie, there's a question for organizing purposes. When, again, is the comment period, or when do we anticipate it to be?
So it could be any day. We're checking the Federal Register every morning. We are basically, if it comes out tomorrow, come out tomorrow, come out the next day. We just know it's going to be sometime between tomorrow and July. So unfortunately, we're playing the waiting game right now, but there are lots of things you can do to get prepared before the rule is published and before the public comment period starts if you log on to the PIF campaign, bit.ly/PIF campaign. So stay tuned.
Great. Josh, there's a question about what you're seeing in terms of DACA renewals and people who submit more than 6 months before their expiration date. Are they getting approved, or are the applications getting rejected?
People who submit that far in advance, those applications are being processed. They're not getting rejected, but there's still a possibility that an adjudicator might choose to prioritize other cases that for people who have whose expiration dates are coming up sooner. But we have seen people who applied with an expiration date that was several months in the future and who have had their applications processed and approved.
Okay, great. So one last question for Jackie before we turn to our next two presenters. Jackie, I know you mentioned that the public charge assessment would likely not be retroactive, but in the example you used of Angie, it looked at the use of public benefits in the past. So could you clarify?
Right, yes, that's always very confusing to folks. So it would not be retroactive in terms of, it does look at benefits in the past, but only if the benefits were used after the rule is published. So for example, if you used cash right now and they're trying to make a determination for the future, because that is what the current rules determine public charge to be, and you used it 2 years ago, you used it a year ago, for example, but you're not using it now, then it is going to take that into consideration in the forward determination of your test. But if you used WIC benefits or SNAP or Medicaid right now, those are not considered public charge. So it will only be considered after the rule is published. So again, you know, if the rule is published, if the proposed rule comes out tomorrow, that's just a proposed rule, we're at least going to have 60 days to have a public comment, and then they're going to have to take into consideration those public comments. So it's only when after that time period, when they publish it, that the benefits beyond cash and care will be counted. At that point, if Angie starts using WIC, you know, after the rule is published, and then applies at some point later for her green card, then it could be considered, but it will not be considered if she uses them prior to the publication of the rule.
Great, thank you both. So next we're going to move to Avide. Avide, you're on, right?
I am. Can you hear me?
Yes, we can hear you. So we'll turn it over to you to talk about the Muslim ban.
Great. Thanks everyone for joining the call today. I wanted to give folks an update on where things are with respect to the latest iteration of Trump's Muslim ban. Just to very briefly recap, I think folks know that starting last January, there was the first version of the ban that was blocked in the courts, and subsequently there was another version that was supposed to go to the Supreme Court last fall, but because it was temporary, it essentially expired, and the Supreme Court said, you know, it was moot and they wouldn't be taking up arguments. We are now on the third iteration of the Muslim ban, and if we could just go to the next slide, I can give a little bit more information about what's in this ban and what's at stake. So the particular case that's going to the Supreme Court, among the many challenges that were brought across the country, is one that was brought by the state of Hawaii and made its way up through the Ninth Circuit. And the Ninth Circuit issued a decision a couple months ago, and then the government requested the Supreme Court to take up the case. So that's the case that's being heard a week from tomorrow at 10 a.m. It's a ban that is indefinite in nature. It's permanent. It specifically targets nationals from 6 Muslim majority countries: Chad, Iran, Libya, Somalia, Syria, and Yemen, as well as most nationals from North Korea, although typically there's very few people from North Korea coming in, and then government officials from Venezuela. So even though this version of the ban, unlike prior versions, added in a couple of other countries that are not Muslim majority and tried to create sort of this window dressing attempt to make it seem like it wasn't trying to target Muslims, you know, we know that the intent behind the ban and the impact as well has been to really go after Muslim populations. Some folks may have seen that the country of Chad was officially taken off of the ban list last week. I think that was, again, another sort of cosmetic attempt by the administration to make it seem like they're not trying to target Muslims. But you know, we're quite confident about the fact that, you know, the same statements that Trump has said and other members of his administration and supporters have used to justify the ban, that remains the same. It's important to also keep in mind that this current iteration of the ban is not only permanent, it's been in effect since December 4th, 2017 of last year. So about four plus months that it's been in full effect. And that's because the Supreme Court basically, without making any statements on the legality or the constitutionality of the ban, said that they would allow for the ban to go forward until such time that they issued a final decision. So what that means is that the ban has been in effect since December, and that it will remain in effect not just through next week's oral arguments, but until such time the Supreme Court actually issues a final decision. And typically, you know, that we would expect that there would be a decision by the end of this current term for the Supreme Court, which ends in late June. So that's kind of what's involved in the particular ban that's being challenged. Going to the next slide, you know, we look at sort of what are the arguments that are being brought forward, and you know, what are the arguments that on our side that we're making. Number one, again, as I said before, that just the intent behind this, regardless of which countries it targets, which populations it targets, that the intent has been and remains the same, which is to ban Muslims from coming into the United States. There's, for example, a separate ban that was issued after this current one that's going to the Supreme Court next week that specifically targets refugees, but they are from primarily Muslim majority countries. So again, there's a lot of different sort of terminologies that sometimes gets used, but from our perspective, it's really important to continue to emphasize that this is and always has been a Muslim ban, and that it's unconstitutional. It violates the First Amendment and the Establishment Clause, and it does so by targeting people of a particular faith. In addition, it's also an unlawful exercise of the president's authority, that even in the realm of immigration and national security, where the president arguably has you know, very extensive authority, that you know, this just goes too far. And those are some of the main arguments that are being brought forward. In terms of you know, some of the things that I think are also important to keep in mind, you know, we're going to be focused on bringing people out, of course, next week in front of the Supreme Court for a rally. But we're also going to be reminding the Supreme Court and the public in general that we've been at this place before. We've sort of been at this crossroads where our values have really been tested. And I think some of the kind of compelling examples that we're going to be lifting up to remind the Supreme Court justices of the historical context is that, you know, back in the 1940s, when we targeted Japanese Americans for incarceration, the Supreme Court really made a mistake in a landmark decision. And we want to really not only lift up the voices of Muslims in the United States who are impacted by the ban and around the world, but also to remind the Supreme Court and send that message that they really don't want to repeat some of those shameful mistakes in our history and in the Supreme Court's history. So some of the things that we're going to be doing in the wind-up between now and April 25th is, again, try to make the connection between the Muslim ban and some of these historical fights, as well as how the Muslim ban relates to a lot of the other attacks that we're seeing on immigrant communities and communities of color. You know, the Muslim ban is just one piece in a larger agenda by the Trump administration to really go after immigrant communities, to really sort of change our immigration laws by attacking temporary protected status for multiple countries, including some of the same countries that are on the Muslim ban. We have a helpful cheat sheet on our website and also on the NoMuslimBanEver.com website if folks want to learn a little bit more about sort of what are the differences between the different versions of the bans, and also how they connect to some of these other issues that you all care about. We're launching tomorrow a digital week of action that will run through next week, and your organizations or on an individual level, you can participate. The main hashtag being used is hashtag #NoMuslimBanEver. There's a form that you can fill out to sign up to learn about what the sample tweets for the day are and what the theme of the day is if you want to follow along for, again, either your organization or on an individual basis. We're also asking organizations to and individuals to come out to the rally that's happening next week. It's starting at 8:30 until about 11:30. As I mentioned before, the oral arguments are from 10 to 11. There's a Facebook event page that you can share, that you can click on the Facebook event page that you're going, or if you want to be supportive but can't physically come, you can say that you're interested. All of that will help generate attention and energy and excitement around that court date. And if you are part of an organization that wants to endorse the rally, you can also do that too. There's more resources and ways to endorse the event if you go to the www.nomuslimbanever.com website. So those are just some concrete ways for folks to stay engaged. I think, for many people, this was the very first fight out of the gate that they engaged in when the Trump administration came into office. And I think for a lot of people, we've had so many other challenges and so many other fights. This is really something that we just want to encourage people to keep on their radar. It's a very high profile moment. Obviously, we hope that the Supreme Court will do the right thing when it ultimately issues a decision, but we also want to send a very strong message that the same communities that are under attack are also extremely resilient, and it doesn't matter what the Supreme Court says. Like, we know from a values perspective that every version of this ban is wrong. So these are just some ways for you all to stay engaged, and hope you can participate. Thanks,
Great.
Jimmy.
Thank you, Abide. Thanks. And as people should continue to write your questions in the comment box. And so next, we're fortunate to be joined by Stephanie, who's the director of TURC, the Tennessee Immigrant and Refugee Rights Coalition, who's going to talk about the large worksite raid that they experienced recently. Stephanie?
Thanks, Shuming, and good afternoon, everyone. I want to thank NILC for the opportunity to share more about what's happening here on the ground in Tennessee after this devastating and massive workforce raid, but also thank NILC for the many, many, many hours and late nights that their team has been on the phone with our staff and members as we navigate how to respond to this raid. So as many folks have probably heard, on April 5th, ICE agents, with the assistance of our local highway patrol, stormed into small meat processing plants in a rural community, Bean Station, Tennessee. So as helicopters were circling above the factory and agents blocked all of the doors, about 100 workers were rounded up and filed onto buses without the opportunity to explain who they were, answer any questions about how long they've been here or whether they were even subject to federal immigration law at all. So we're still working closely with NILC and others to investigate the conditions at the factory, how the raid was conducted by federal agents, but workers at this point have reported rough treatment and detention. Many, despite having work authorization, there were just countless violations of the law and basic constitutional rights. But in total that day, ICE arrested 97 workers. So 11 of those folks remain in Tennessee in local custody on state and federal charges. 32 were released that night, largely women with young children, others with pressing medical conditions, but they too are now in deportation proceedings and have already been scheduled for their check-ins with ICE. And 54 of the 97 workers are still being held in detention centers in Louisiana. So these community members, many of whom had been here living in Tennessee for decades, some who had been working at this plant for well over a decade, were shipped out of the state that night without a chance to say goodbye to their kids or their loved ones. Their families were told nothing, were left to wonder what had happened to their loved ones. So the photo that was on the previous slide was of an elementary school that was actually right next door to the National Guard Center, where workers were taken from the factory, bused to the National Guard Center, and processed for hours. And so until the very early morning hours on Friday, family members were waiting, lawyers were interviewing people, volunteers were showing up with supplies. And so, as you can imagine, a raid of this size has really created a humanitarian crisis here in Tennessee. So far we've counted at least 160 children, many of whom are U.S. citizens who have at least one parent that was arrested on April 5th. Many kids saw their mom, their dad, their aunts and uncles, all arrested. 108 of those kids have a parent who's still in detention. But as we also know, the fear and trauma that is caused by raids like this extend well past the families of those that are arrested. So on Friday, the very next day after the raid, just one county school district reported that nearly 600 kids were absent. Many workers didn't show up to work the next day, and many parents, having seen what happened to those who worked at Southeastern Provision, have started making emergency plans for their children. So just in the last week and a half, we've already helped 350 parents in the Morristown area to execute powers of attorney to designate guardianship for approximately 750 local children in the event that they are detained or deported if ICE comes back. So the level of fear and trauma in the wake of this raid can't be overstated, and I'm sure that extends to many of your communities as well. Next slide. So since the raid on April 5th, I think the only way I can describe it is that local organizations and community leaders have essentially set up a disaster relief center out of a local Catholic church to address the many and urgent needs of the hundreds of families whose lives have been torn apart. So families need trauma counseling, legal support, and basic assistance just to feed their families since many wage earners were taken from their households. We've spoken to some families who have up to 7 members in detention from this workplace raid. But since the election of Trump, organizations like Turk, we've been readying ourselves and building the infrastructure to respond to this kind of crisis. So we quickly stood up an intake center, both remotely where we could receive calls and again at the school next to the National Guard Center where workers were being processed. So the quick organization of workers, their families, legal volunteers ensured that we quickly gathered critical information to build a powerful legal defense. By the end of the Thursday night, the day of the raid, we had more than 80 workers accounted for of the 97, and we're in close contact with their family members. So in partnership with the amazing folks at NILC and with the Southern Poverty Law Center, we've been securing legal representation for all of the workers and are continuing to investigate the role of the employers, the condition of the factory, and all of those things that might support the legal defense of the workers. But families, in addition to like I described, sort of being under incredible stress and trauma, have also really fearlessly come together to defend their loved ones. They've shared their story in the media. They've provided eyewitness accounts of what happened in the factory for those who were released. And they've been organizing public actions, like a procession through Morristown last week with more than 300 members. And they're getting ready to do another action outside of a local member of Congress's office, calling for the release of their loved ones. But the organization of impacted families is really matched by just an incredible outpouring of support by the local community in Morristown. So the church where we've assembled these rapid response services is just overflowing with donations and volunteers. Just 2 days after the raid, 120 local teachers gathered to strategize. The next Monday, nearly 1,000 gathered at a local elementary school to show their support for the family. And so, next slide. So the disaster from this raid, it continues to unfold. In some ways, I can't believe it's almost been 2 weeks. In some ways, I can. But As we know from similar raids in previous decades, the impact of this raid on children, on the school system, on the economy, on the families with folks detained will last for many years to come. But I think what gives us hope is that the overwhelming support these families have received from their neighbors in this rural, overwhelmingly conservative East Tennessee community really demonstrates that ICE and the Trump administration's cruel enforcement tactics are really out of step with the values of Americans and Tennesseans, and really the expectations we have about how workers and families should be treated. And so we have been working pretty much around the clock since the raid to investigate what happened and support the families and mount deportation defense cases for everyone, while trying to make sure that the country hears these stories coming out of Morristown. And so we know that these are all the reasons why this egregious tactic of mass workforce raids haven't been used in the last decade. And so we hope, with your support, that the growing movements building from the aftermath of this raid can help make sure that this is the last one that we see. And so we're working closely with NILC and other national partners to develop demands for Congress, for ICE, for local policymakers, while providing that critical and ongoing support to the deportation defense of the 97 arrested workers. So we're going to need you to stand with these families in Morristown for many weeks to come and help us to build up a powerful national movement against these raids. But in the very short term, we're asking folks to sign the petition. You can see the link on your screen. We'll be delivering these very soon. I think we already have more than 6,000 people across the country who've signed on. We're going to deliver these signatures very soon to the field office in Louisiana, where the 54 workers are being held. So please sign it and share it and help us demonstrate to ICE just how many people will be fighting to bring these folks home. And we hope you'll spread the word about the raids and share stories, talk to your local elected officials, businesses, and others to condemn this raid and the tactic more generally. And then follow Turk and NILC for different ways to support, of course, these individual deportation defense cases, as well as opportunities to advocate for broader national demands around workplace raids. And then lastly, we know that this kind of workplace raid is what Trump campaigned on. It's what the ICE director promised we'd see more of this year. And so Morristown is a rural community where this happened. There aren't immigration attorneys or really any legal infrastructure to speak of. There aren't mental health resources. And so in the wake of this raid, the community has really come together to develop and stand up a really incredible and robust infrastructure to respond to the raid. So we've learned a lot of lessons, developed a lot of resources, and we'll be working to develop these. So we know many of you have asked for this kind of information to help you stand up a rapid response infrastructure in your community. So stay tuned for those as well. But I will stop there and look forward to answering any questions. And again, just keep following Turk and NILC, because we'll have many, many ways for you to keep standing with the Morristown community.
All right, thank you, Stephanie. So we still have questions coming in. There's two I'm going to ask you first, Avide. One is, what would be the effect of the Muslim ban on asylum seekers from those countries?
Thanks, Shuming. So asylum is something that someone applies for once they come to the United States. So if someone is prevented from being able to come and they're from one of those countries, then they're not going to be able to make it to the United States in order to make that claim for asylum. So I think the person who's asking this question is really raising, a really important point about the fact that it's going to obstruct the ability for people to seek humanitarian relief. We're obviously also already seeing the impact on refugees. Those are people who are able to get refugee status outside of the United States, and for many of those people, they're not, despite in some cases waiting years for clearance and going through all of the various background checks and other hoops, because in part of the bans, and also in part from the fact that the administration has completely outside of the ban just drastically reduced the number of refugees that are being resettled. the cumulative effect is that we're seeing not only that, families aren't being reunited, that people aren't going to be able to pursue educational or professional opportunities, but that in terms of the humanitarian obligations that we have, like we are really going to be falling short and already certainly are falling quite gravely short. So some of you may have seen, for example, the fact that there was a reports last week saying that 11 Syrian refugees, that's just one of the countries, have been resettled in the United States in this calendar year. And so all of that is, of course, extremely troubling.
All right, thank you. The other question for you, Avide, is what are the connections between the termination of TPS for some countries and the countries that are included in the ban?
Sure. I mean, before I jump into that specific connection, I think I mentioned before that it's important to draw the links, and I think that the administration has an objective in targeting Muslims and banning them from coming to the United States. So that manifests itself in these different iterations of the Muslim ban, but it also plays out in other ways that the administration is able to achieve. And one of the many ways is the fact that it has targeted certain countries that have been designated with temporary protected status. It's targeted those countries by terminating temporary protected status for those countries. So if you look at, for example, the fact that countries like Somalia, Sudan, Syria, Yemen, those are all countries that have previously been designated temporary protected status and have either lost it or are at risk of losing it in the near future. And those are all countries that are also on the list of countries banned under this 3.0 version of the ban. And I think that's just important to keep in mind, that there are different ways in which the administration is using other policies that allow it to target Muslims. Another example I would lift up is in a lot of the negotiations around the possible passage of a DREAM Act that was very much in play in Congress over the last several months. There was so much attention and discussion around the diversity visa lottery program and threats to drastically reduce it or eliminate it altogether. And, thankfully we were able to fight those legislative threats. At the same time, if you look at the fact that we have this ban in place, even when there have been exceptions that have been made, people who don't have ties to the United States, and by definition, those are diversity visa lottery winners. That's exactly why we have that program. They are not going to be, if you're from one of those banned countries, you're not going to be able to get in through those programs if you don't have ties to the United States. So I think all of these the cumulative effect, again, of all of these different threats is that they target Muslims in one way or another. So again, pointing to the fact that this particular case is extremely important, and it sends a huge message to the American public and really to the world. But at the same time, our fight extends beyond this one case.
All right, and as we're getting to the end, I have two questions I'll ask you, Stephanie. I'll just ask them at once. One is, did ICE disclose why they targeted this plant? And the second is from a person who might be able to take on some pro bono bond hearings from Texas, and they're wondering if telephonic bond hearings would be allowed.
So we are still investigating exactly why ICE targeted this specific factory, and especially why they conducted the raid as they did. From what we know, it seems actually that the factory came on the radar of ICE through an IRS investigation, that the company had some tax violations, and it was clear that they were paying folks in cash and different things like that. So we're not sure exactly how ICE or why ICE collaborated with the IRS, and it's unclear what, if any, penalties the employers themselves will be facing. But it seems that it wasn't ICE necessarily targeting the meatpacking plant on its own if it hadn't been for the IRS investigation. And yeah, we are looking at a lot of different strategies to bring in pro bono attorneys from outside of the state. As I mentioned, our private bar and nonprofit legal infrastructure is quite thin, especially in rural East Tennessee. And so for the bond hearings, the Southern Poverty Law Center is coordinating in Louisiana the pro bono attorneys to help in that way, and then also for the individual representation and the legal screenings and legal support for the 32 folks who were released but and are at home in Morristown but still needing to go through the removal process with ICE. We are looking at how we might be able to stand up remote legal screenings or other kinds of representation. So for any of those questions, if folks who are interested would just email me, it's Stephanie, STEPHANIE @tnimmigrant.org, and we can connect you with either SPLC for the bond hearings or with our team for broader screenings and representation work.
Great. Thank you to the 4 presenters for sharing a lot of information in an hour's time. And to those of you who are attending, again, you will receive a copy of the PowerPoint and a link to watch the video recording this week. And we wanted to thank you all for your patience. I know we had a couple of second delays at several moments in terms of getting the slides up on the screen, but you will have all of them so that you can review them at your leisure. And we'll continue to have these webinars at key moments in the immigrant rights movement history. And if you have suggestions for topics you want us to cover next time, we'll be sending you a survey along with a copy of the PowerPoint. So feel free to let us know what you would like to see covered in the future, and join us in the future also.